welcome to Barra Legal News. I'm Sharon, bringing you the latest. In today's feature segment, we'll be discussing the proposed £200 million merger between the food ordering giants JustEat and Hungry House. The merger has been referred for an in-depth investigation by the UK's leading competition law authority, the CMA. The CMA's decision is due to be announced in November 2017. However, before we begin to look at the investigation in detail, we must first explain exactly what competition law is and why it is so important. Competition law is designed to regulate anti-competitive behaviour within the marketplace by intervening when there is an issue with the competition process. While this may seem irrelevant, it is in fact vital to the efficient running of markets and the protection of consumers. The foundations of competition law are formed from the neoclassical economic theory, which states that in order for perfect competition to exist, there are some requirements which must be present in the market. The first requirement is that there must be identical products. Next, there must be an infinite number of buyers and sellers in the market. Thirdly, there must be free entry and exit. And finally, full information must be made available to all buyers and sellers within the marketplace. This theory is based on the belief that consumer welfare thrives when a state of perfect competition exists. With this in mind, the Competition Authority's main aim is to make sure that companies are constantly competing with each other in order to keep prices low and ensure the good quality and varied choice of products. In the absence of competition law, market failure can occur, which can have very damaging consequences for businesses and unsatisfactory effects for consumers. For example, if two similar companies operating in the same market merge together in a takeover, they can gain majority control of the market share. This could result in the combined company pushing out other businesses, so they are the only business left within the market. Once this is achieved, they can then manipulate the market by raising product prices, which would be to the consumer's disadvantage. This is exactly the type of behaviour that the competition authorities seek to reduce and eventually eliminate. There are many different forms of anti-competitive behaviour, and the three main issues that the competition authorities are concerned with are monopolies, anti-competitive agreements and mergers, with the latter being the type of behaviour investigated in the JustEat Hungry House case. But what exactly is a merger and why are the CMA investigating it? A merger, sometimes referred to as a takeover, is a deal agreed by two companies to unite into one. This also describes a situation where a predator company takes over a smaller target company in what is known as a hostile takeover. Most business shareholders agree on a merger deal taking place to improve the efficiency of the companies involved, and mergers can even act as a last attempt to prevent the closure of a company. While mergers are not necessarily bad for competition, they can have significant implications on the economy and markets which require some degree of activity control. The principal focus of this merger control relates to the potential competitive repercussions that may emerge as a result of the increased concentration in a market caused by a merger. Merger control is provided by the CMA, who investigate mergers for potential obstacles in competition. The three types of mergers which may affect competition and be investigated by the CMA are horizontal mergers, vertical mergers and conglomerate mergers. Horizontal mergers are usually the greatest concern for the CMA. A horizontal merger occurs between companies that operate at the same level in the market. The JustEat Hungry House merger would seem to be a horizontal merger, as both companies currently operate in the online food delivery service market. This type of merger, at the same time as benefiting the companies, would possibly hinder competition, as two competing businesses would join together and most likely be in a dominant position in the market. The potential effect of this merger has serious consequences for the market, which is why the CMA has decided to step in and launch an investigation. We'll now take you to our on-the-ground reporter Vera for this moment.
Thanks, Shannon. So, how does JustEat and Hungry House merger fit into this picture? In 2001, JustEat was created in Denmark before launching its first UK enterprise in 2006. Today, it has 75,400 restaurant partners, over 100 cuisine types, over 2,370 employees and 19 million customers worldwide. In 2014, JustEat became a public company. It's safe to say that JustEat is one of the biggest order online services in the UK. Let's bring our attention to Hungry House. The order online service started from humble beginnings before catching a lucky break on Dragon's Den. Co-founders Shane Lake and Tony Charles secured an investment in the Dragons in 2007, and in 2012, House merged the food ordering giant delivery for Delivery Hero. According to the latest figures, Hungry House now has over 11,000 restaurants subscribing to its services. So, what's all this fuss about the merger of Just Eat and Hungry House? In December of last year, Just Eat announced that it would be acquiring Hungry House for a sum of $200 million, which is no small figure. Such a merger would expand Just Eat's growing empire, so there's no surprise that the CMA has something to say about it. What exactly is the UK's watchdog so concerned about? According to the CMA, there are several reasons why such a merger could have an impact on competition. The principal concern is that the merger will result in a lessening of competition in the online takeaway delivery service industry. Why, I hear you asking? Well, in simple terms, because Just Eat and Hungry House are said to be very similar companies in terms of the services they provide and cover a wider geographic area. The two companies both have independent restaurants who subscribe to their online platform and deliver the food themselves. The idea being that by making such subscription, independent restaurants will see an increase in customers as a Just Eat Hungry House system is more available to the average consumer. Therefore, once Just Eat and Hungry House merge, they would not be as competitive in comparison to their current competition levels in terms of the amount they charge restaurants for subscribing to their websites. The CMA is concerned that the lessening of competition arising from such a merger could impact on restaurants currently using either company, as well as restaurants who are not subscribed to the two companies. In addition, there would be a foreseeable increase in competition of subscribed restaurants, as the merger would result in a higher number of competing restaurants within its database. For the restaurants in the geographical area who are not subscribers, there are concerns that they would likely face an unfair amount of competition locally. In retaliation, Just Eat has argued that Hungry House is not a main competitor, as less than 15% of Hungry House's restaurants are classed as unique, which, according to the company, means that the merger will not have a significant impact on UK competition. Nonetheless, the merger can be detrimental to companies such as Domino's Pizza and Delivery to Go. These customers use a similar app service. Indeed, Domino's share prices are predicted to fall significantly if the merger is successful, despite the many hungry students who view Domino's as a godsend. As Just Eat already has a very large market share, the merger with Hungry House could result in warding off any competition. Furthermore, the CMA has concluded that as such companies, like Deliveroo and Uber Eats, focuses on a smaller geographic area and deliver the food themselves, Just Eat Hungry House cannot be considered as rivals within this area of competition. Therefore, if the merger is successful, Just Eat will not have a significant rival to compete with, and consumers will ultimately be affected. Hungry House and Just Eat disagree with this conclusion, claiming that the CMA has dramatically underestimated the competition they face from such companies, and that they already materially affect the dynamics of competition in relation to the provision of takeaway. So, as we've seen, there are a lot of different factors to consider, and the CMA have their work cut out. So, what stage is the investigation currently at?
The merger has passed phase 1 of the investigation, and Just Eat was given the opportunity to address the CMA's concerns. However, as they have failed to do so, the investigation has now been referred to the more in-depth phase 2. The CMA has until the end of November to reach a final conclusion, so of course, we're all waiting with bated breath. So now that we're all completely confused, let's talk to the professionals.
Hello and welcome back to Bar Legal. Today I'm joined by a member of the investigatory panel from the CMA, who considers alleged mergers. So, Sarah, would you mind giving us a brief explanation of the investigatory process?
Hi Bella, yes of course, I'll keep it short and brief. So UK merger investigations like the Just Eat Hungry House one are carried out by Part 3 of the Enterprise Act 2002, but there have been a few amendments after the enactment of the Enterprise Regulatory Reform Act 2013. So investigations were previously done by the Office of Fair Trading, however following the 2013 Act, the task is now done by the Competition and Markets Authority. So a merger is defined in Section 23 of the Act as occurring when two or more enterprises have ceased to be distinct enterprises, so they're both under common control. There are different ways to assess whether the undertakings are in common ownership under Section 25 of the Act, but I won't go too much into that. So firstly, a merger must be reviewed if it satisfies the turnover test. So that is, UK turnover is more than 70 million. or if the merger buys or supplies goods or services of a kind that is 25% of the market share in the UK.
Interesting. So how does the CMA investigate the merger's activity?
Well, if either of the thresholds are met, this starts the Phase 1 investigation. So the CMA has 40 days to see whether it should continue to Phase 2. So this is either the first day after the party has voluntarily notified the CMA via merger notice, or the first day after the CMA has enough information to begin its investigation. So the Phase 1 investigation is conducted by the CMA Mergers Unit case team, who investigate whether the alleged merger is serious enough to qualify for a Phase 2 investigation.
Is it a long process? I'm guessing there's a lot of different steps to it.
Yeah, definitely. The CMA will request information from the mergers and may even contact third parties regarding this information. So there will then be a series of meetings regarding the merger, the number of which will all depend on the complexity and the seriousness of the case. So if after the 40-day period the CMA doesn't qualify as a merger, or that the merger would lead to potential lessening of competition, then one of the directors within the CMA unit will clear the transaction. Or parties will be referred to Phase 2 of the investigation if they believe there is substantial lessening of competition.
So is there a way for the parties to get out of Phase 2?
Technically, yes. Parties can't stay any remedies or binding commitments to change their behaviour or the structure of the company, so they won't be breaching any competition rules. These are known as undertakings in lieu. Also, the CMA has to double check whether the undertakings in lieu will benefit the customer.
It seems like a complicated process. So what would happen if parties went to Phase 2 for further investigation?
So the Phase 2 investigation is a much more complicated process to see whether the merger is indeed a merger, or if the activity from the alleged merger may result in a substantial lessening of competition.
And what exactly do you mean by the substantial lessening of competition?
So the SLT test is found in Section 22 of the Enterprise Act. So it basically means that the merger's activity might have a detrimental impact on the competition or rivalry process, and therefore on its customers. The CMA will look into the market and its shares and different structural factors to see whether the merger will negatively impact the market.
And what happens in Phase 2?
So the CMA has 24 weeks to come to a decision, however may potentially extend the period another 8 weeks. Investigations are carried out by an inquiry group, which is composed of a range of different professionals, so lawyers, academics, etc. Firstly, the CMA gathers information about the potential infringing behaviour carried out by the merger, whether that's from questionnaires, submissions, hearings, or other methods.
And what if the parties don't want to comply or cooperate with the investigation?
There can be a range of fines, sometimes up to £15,000 per day if parties don't adhere to the CMA's requests. Then there will be a Phase 2 assessment, which is comprised of a hearing with the parties and an issue statement given by the CMA. Afterwards, the CMA will state its findings, which will also contain a notice of possible remedies, and the CMA will publish its final report. Finally, after the final report has been published, the CMA decides if the merger would result in substantial lessening of competition. So it has 3 possible options. 1, complete clearance. 2, clearance but with regard to remedies. Or 3, prohibit the merger entirely.
And what about if there's evidence that there's a merger that satisfies the SLC test?
So if it is evident that the merger may result in a lessening of competition, it has 12 weeks to implement remedies which may rectify this.
And what if parties aren't happy with the CMA's decision? Is there any way to argue against it?
The Competition Appeal Tribunal can appeal decisions made by the CMA.
Thank you for your time, Sarah. I think that was very informative. Now we'll speak to our second guest, who is Brona Miller. Hello, Brona. Would you mind giving us some insight into the process after the investigatory stage? Are there any remedies available?
Hi Bill, yes of course. Basically, if the inquiry group decides that the outcome as a result of the merger was anti-competitive, then the CMA has the primary role for taking remedial action following a market investigation. Sorry to bore you with the legal jargon of it all, but under subsection 82 and 84 of the 2002 Act, the CMA may exercise its order-making powers or accept undertakings from parties. It has a duty under section 41 to take such action as is reasonable and practicable under subsection 82 and 84 to remedy, mitigate or prevent substantial lessening of competition concerned and any adverse effects as a result.
So what happens if the parties can't agree on such undertakings?
Schedule 8 to the 2002 Act specifies what may be included in an order. Although there are no statutory limits on the CMA's power to obtain undertakings, additionally, the government via Secretary of State cannot intervene with the CMA merger decisions except in a number of limited circumstances, which include those involving issues of national security, media plurality, quality or press freedom, and where the stability of the UK financial system is at risk. If undertakings to remedy the findings cannot be agreed with the party, the CMA will make an order imposing the remedies.
Okay, interesting.
What are the types of remedies available?
The types of remedies available include divestiture of business or assets, removal of entry barriers by requiring know-how licensing, either the discontinuance or the adoption of specific behaviour or the imposition of a price cap, or monitoring of price and profits.
And how does the CMA decide which remedy to use?
Good question. The CMA, when making decisions, is allowed under the Enterprise Act 2002 to take into account any customer benefits derived from the market feature, such as lower prices, higher quality or choice of goods, and greater innovation. The CMA adopted the guidance on merger remedies, which was introduced by the Competition Commission, providing detailed guidance and information on the remedies available and the level of appropriateness.
Brilliant! And are there any specific type of remedial action which the CMA prefers to utilise?
The CMA does not generally favour behavioural remedies, as they require a greater level of monitoring by the CMA. Thus, a structural remedy is more favoured, but of course the level of appropriateness always applies.
And how about appeals? How does the process for that operate?
The merging parties and any interested third parties in concern with the decision made by the CMA can apply to the Competition Appeal Tribunal, or CAT, for review of any decisions the CMA or Secretary of State made. In merger appeals, the type of review is solely on points of law and not based on the merits. The CAT will review the CMA's investigation and materials in order to assess whether the CMA's decisions are reasonable and demonstrate sufficient grounds for the conclusions reached. It is also possible to apply for the judicial review of the CMA's decisions directly to the High Court. This is very rare. Under Part 3 of the 2002 Act, any CMA decision is subject to judicial review by the CAT and therefore on appeal to the Court of Appeal in England and Wales and the Court of Session in Scotland.
So, are the causes for appeals limited or not?
Appeals can be brought against any type of merger decision by the CMA, including clearance decisions, reference decisions, including decision not to refer, remedies, prohibition decisions, interim orders, and fines imposed for failing to provide information or providing inaccurate or misleading information.
And does a time limit exist for any appeal?
An appeal must be lodged with the Competition Appeal Tribunal within 4 weeks of the CMA's decision. The CAT will then aim to conclude all appeals within 6 months, but this is not a legal requirement. Furthermore, an appeal of the judgment of the CAT on points of law can be made to the Court of Appeal within 14 days.
So is it common for appeals against merger decisions to occur?
Appeals against merger decisions have been relatively rare since the establishment of the CAT, although you may be aware of the Ryanair appeal in 2013, where Ryanair appealed the CC's decision that their shareholding in Aer Lingus lessened competition. They argued that the decision was contrary to the EU duty of sincere cooperation in circumstances where an appeal to the European courts was still outstanding in respect of the European Commission's 2013 decision to prohibit the merger between the two Irish airlines. The CAT, Court of Appeal and the Supreme Court all dismissed such arguments though.
So are there any penalties involved in the process?
Notification is indeed voluntary, however failure to comply with investigatory requirements could result in the CMA fining a party who fails to intentionally or without reasonable excuse. Additionally, failing to attend interviews or meetings with the CMA is a failure to comply. Administrative penalties can be imposed as a result in the form of fixed amounts, either £30,000 or a fixed amount penalty of £15,000 for a daily penalty. Furthermore, if a party fails to comply with any undertakings it is given, or an order imposed by the CMA, civil proceedings for an interdict or injunction can be imposed by the CMA, or UK courts can apply other appropriate remedy to the case at hand. Third parties involved in this who were affected either by loss or damage could also bring such to action. All in all, there is also the potential imprisonment of up to 2 years.
Sounds like serious stuff. Thanks for your time, Bruna. That's all from us today. This is Villa Hornsby reporting at Barra Legal, and back to you, the studio, Shine.
Thanks for watching Barra Legal News. Tune in next week for more updates on this topic. Good night.